This is what I was thinking, and I'm making myself clear so that they also get to know. There is an issue of stigmatization which was highlighted yesterday, that if the list of the tainted candidates is published, then these candidates get stigmatized. So why not publish the list of the candidates not specifically tainted? So at least for the time being, they can avoid the stigma. As of now, you are not in the tainted list.
I am not in the tainted.
So if they publish a panel not specifically tainted, your name may go there.
There is no difficulty.
Thereafter, the court hears the matter and comes to a conclusion that the candidates who were given appointment after expiry of the panel will be treated as tainted, then your name will automatically go out from the list of the not specifically tainted.
This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
But I'm appearing on behalf of the petitioner, my lord.
Yes.
This matter relating to, my lord, Group CD, the last date of online application is 3rd. My lord is well aware.
It has been extended possibly
It has been extended.
till
Extended.
till
Eighth.
8th.
My lord, I am praying for.
Has kept one matter on 8.
Of Mr. Laidi's matter has been kept on 5th.
My lord, but this matter relating to, my lord,
No, the
this
extension
candidate.
is till 8th.
Yes.
My lord, this matter
Yes.
relating to, my lord, all the candidates, they are waitlisted candidate in the 2016 selection process. Now, my lord, all the petitioners, they are age bar because they wants to fill up the form. They says you are not entitled to get the age relaxation. Kindly turn, my lord, page number 154.
Filling up the form, this process ended in June.
No. It's going on.
Oh, this is the
Group CD.
All right, I
That's
got mixed up.
That is
Sorry, I got mixed up. Yes, process is going on.
process is
Cannot
going on.
because you are age barred.
My lord, kindly turn page number 154.
154.
Why I before this court, my lord? I just
Yes.
annex one. My lord, the last portion, this roll number or name against it is not entitled for age relaxation. You should keep this field blank instead. So I am not getting the age relaxation. My lord, kindly take the apex court judgment. Kindly turn page number 125. The judgment start from page number 85.
Hmm.
Para 49. I read it. The disabled candidate mentioned in this previous paragraph will be allowed to participate in the fresh selection process, if required, with age relaxation and other concession. Similarly, that means in the same line,
Hmm.
other candidates, not other employees or other teacher or non-teaching staff, other candidates who are not specifically tainted. So whosoever, so tainted candidate is two class. One is who are getting service and who are not getting service. Both are in the tainted category. Because my lord is well aware that Polash Noskor matter, my lord already passed order. So who are not specifically tainted? We are those candidates who are not specifically tainted, not get service. So we also entitled to age
To age relaxation.
who are not specifically tainted will also be eligible to participate with appropriate age relaxation. In our opinion, such direction would be fair and just, as it would allow this candidate to take part in the fresh selection process, which should now be initiated to fill the vacancies. Very recently, my lord, Supreme Court in Vivek Paria matter passed the judgment, passed the order, my lord, in the same line. I just placed it, my lord, in Vivek Paria. That is 26th November 2025. I just placed it, my lord. The relevant paragraph, page 8 onwards, my lord. Page 7, last paragraph. We are informed that a writ petition being WPA number 26288/2025, that is Mosumi Mandal matter, today is in the list. I will place it accordingly at that time of when I will place that matter, my lord, has been entertained by a learned judge of the High Court at Calcutta, and various issues were flagged by the learned judge in her order dated such and such. 4 dates are mentioned, passed therein. The matter on the file of this court as on date were kept pending only for the purpose of verifying whether the direction of this court in the state of West Bengal versus Boishaki Bhattacharya Chatterjee and others were implemented scrupulous. As a learned judge of the Calcutta High Court has now taken up that issue also, we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertake the exercise instead of this court. It would be open to all petitioner stroke applicants before this court to approach the High Court for redressal of their lawful grievance in accordance with law. The High Court shall, however, ensure that none of the tainted candidates are permitted to slip through in the test selection, be it on any pretext. The High Court shall also ensure that the listed of tainted candidate is placed in the public domain with full details so as to ensure that this does not happen. Learned counsel in some of the cases seek relief in terms of certain paragraphs of the decision in Boishaki Bhattacharya Supra. They are liberty to raise such hermeneutic exercise before the High Court. The special leave petition application disposed of in aforesaid terms. The next 2 paragraphs is very important. The High Court shall examine the matter uninfluenced by any of the observation on merits made by this court in the order passed after the decision of Boishaki Bhattacharya Chatterjee Supra. The High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection test to be held afresh, and their candidature, what is very important, candidature cannot be adversely affected by application of the new rules. That is the West Bengal School Service Commission selection for appointment to the post of assistant teacher for upper primary classes such and such, rule 2025, pending application if any shall stand disposed of. So court intention is very clear. Whosoever not specifically tainted, they ought to give an opportunity, and the new rule must not be impediment for getting service. And I have, my lord, multifold prayer already, my lord.
Where is the rule? Show me.
My lord, I placed first. Rule is page number 63. My lord, before that, my lord, I placed the advertisement. Because why I placed advertisement, my lord? I will place because of that, my lord. I challenge the applicability of the new rule also, and in the line of the Supreme Court recent order, my lord.
Yes.
No, my lord. Advertisement is page number 79. Notification, and very important, my lord.
Yes.
First state level selection test 2025 for recruitment of non-teaching staff, clerk, group D in recognized government aided sponsored school in West Bengal. In compliance with, that is this advertisement in compliance with the order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024 dated 3rd April 2025, which I placed just before it. The West Bengal School Service Commission is commencing selection process to the post of non-teaching staff in recognized government-aided sponsored school in West Bengal. Accordingly, this notification is being issued for conducting first state-level selection test. The selection to be post of non-teaching staff, such and such. I just now, my lord, this is the last line, which is contrary to the order. Accordingly, I just placed it again. Accordingly, this notification is being issued for conducting first state level selection test for selection to the post of non-teaching staff in recognized government-aided /sponsored school in West Bengal against the vacancy to be received from the West Bengal Board of Secondary Education under the West Bengal School Service Commission selection of person for appointment to the post of non-teaching staff rules 2025. Earlier rule was 2009. That rule is also annexed to my writ petition, page number 135. This selection process will be governed by the West Bengal School Service Act 1997, subsequently amendment, NTS rule 2025 and relevant state government guideline. Any citizen, that is the portion, I just keep it over. Malad, the age, page number 82. That is age. Eligibility. Para 7, page number 82. In clerk post and group D post, there are two type of posts. Last paragraph, last column, that is age limit. Minimum 18 years and maximum 40 years as on 1st January 2025. They make this age bar, but the Supreme Court intention is very clear. Whosoever the untainted candidate, they ought to give an age relaxation. They give an age relaxation to those candidates who got appointment. They not give age relaxation to those candidates who are waitlisted candidates, who are
There is a
untainted.
note just below.
Yes,
Age limit,
yes.
provided age relaxation will be given.
I will place it. I will place it. They says in accordance with the rules, in accordance with the judgment, but they not give it. Judgment is very clear. Judgment says whosoever untainted, or not specifically tainted candidates, but they give it to the candidates who got appointment, not the others. Now, my lord, what is my prayer? In this context, judgment press close this. My lord, prayer B is regarding age relaxation. 2005 rules, virus challenge is there, my lord. My lord, I want the applicability of 2009 rules, that is there in this the same Supreme Court line, my lord. I want, my lord, the list of all the tainted candidate and not specifically tainted. Why? Because I came under that category. That is not specifically tainted. That list is very required. Otherwise, my lord, who will get that age relaxation benefit? It is non-ascertainable. So that's why, my lord, I want two lists. One is tainted list, another one is not specifically tainted list. Because in that category, two types of candidate will be there. One is that who got appointment, who not got appointment. So these two categories, my lord, is necessary. And in this line, my lord, already, my lord, passed in Polas Noskor matter, my lord, already passed the order, my lord. Tainted candidate list, my lord. And another thing, my lord, because in tainted category, my lord, I missed this on the last occasion, my lord. Another category ought to, my lord, inserted. Kindly turn page number 190. That category ought to inserted, my lord. Page number 119, that is, and board ought to made a party.
Yes.
Here board is party here. It is also important, para 37, my lord. It is also important to refer to another finding recorded in the impugned judgment regarding a discrepancy in the recommendation made by WBSSC and the number of appointment letter issued by the board. The investigation revealed the following disparities between the number of candidates recommended for appointment by WBSSC and the number of appointment letter issued by the board. So, number of appointment letter is higher than the number of recommended candidate in four category, my lord. It is mentioned how many excess number of appointment letter is issued by the board. The very next, my lord, very next page. When comforted, the board has proffered that all appointment letters were issued on the recommendation of SSC, WBSSC. Same thing had happened, my lord. Because of that, in that line, my lord, first severe investigation was directed, my lord. On the other hand, the WBSSC contradicted the stance of the board by stating that they had not issued recommendation for the excess number mentioned by the board. So there is a conflict between two Article 12 authority. They ought to sit together, my lord. Who are the excess candidate, my lord? WBSSC and the board now claim that the discrepancy in the number of appointment letter issued is incorrect. The board counted all letters without adjusting for candidate who did not join, while WBSSC excluded those candidates from its recommendation. Therefore, there is no discrepancy for teaching staff, and the small differences of non-teaching staff is irrelevant, as many of these candidates are already on the tainted list. for rank jumping or being out of panel. We reject this late attempt by WBSSC and the board to reconcile the figure as the number of recommendation made by WBSSC is independent of whether the candidate joined the post. So, my lord, that category also put in the tainted category list because whosoever, because they have to tally it. There is apparent that excess appointments are there, my lord. It is evident from the chart itself. So they ought to
And
even
is this for 9, 10, 11, 12, Group C, Group D in
all categories. I will place in Mosumi Mondal matter, my lord, all category it happened. And not only that, in 9, 10 category, my lord, they just put 1,806 candidates. But if I go through, because Mosumi Mondal is also in my lord list, today's list, my lord, and in respect of Mosumi Mondal matter, my lord, the apex court passed this order, my lord, by mentioning that WPA number, my lord, that number also be higher. Because of that, my lord, this tabular chart, which is annexed in page number 113 in 9 category, my lord, just 19, I just, because my lord arose this question to me. My lord, kindly take page number 113 in 910 category. There are total rank jump and out of panel 185. Thereafter, my lord, 38. Got it, my lord? Combination of two. Thereafter, OMR sheet 952 and 907. কত আসছে দেখতো 2082 বোধহয়।
Yes.
185 plus 38 plus 952 plus 907. Most probably number 2082. So
Whatever.
they published 1806 candidate list. So that number ought to be the higher because of they all are tainted candidates. Might be they not get the service, but they are the tainted category candidate, which is evident from this tabular chart, my lord. So whosoever in group CD, my lord, I place this matter. Whosoever the not specifically tainted is entitled for age relaxation. For the time being, as an interim measure, give that malad age relaxation and give a chance to fill up the form malad in the ensuing recruitment process malad.
Yes, Commissioner.
208.
That
Yes,
is-
that number is 208 malad.
The rule is under challenge. I'll hear the state also. But then the interim relief regarding the age relaxation to candidates who appeared in the examination.
That perhaps has been decided in Arunima Pal's matter for 9, 10, 11, 12. Paragraph 30 of Arunima Pal's order, my lord.
What does it
Age
say?
relaxation, my lord, is same points were urged. Kindly seize, my lord, Arunima Pal's.
Is it annexed?
No.
No.
Sir, if your lordship is having one of the compilations, either by the
You know what
commission or-
happens? The compilation goes with the file. So
My lord,
I can return it to you.
yes, no, that is
Because in each and every matter this is being used.
one compilation.
Has to
Lord,
be kept over here separately, yes.
the latest compilation filed by the commission, my lord, has all the documents.
Is this the one?
This is the one.
Right.
সেটা কোনটা এটা
Second বলে যেটা
এটা
যেটাতে 381 পেজেস আছে।
হ্যাঁ
তুমি অরুণিমা পাল্টা কি তোমার
My lord, the Arunima Pal judgment of the division meaning 152, starting at 152.
kindly seize paragraph 30 at internal page 18.
মাইকটা দিয়ে দাও, এই মাইকটা শুনতে পারবো, এই মাইকটা বিশ্বরূপের দিকে দিয়ে দাও।
Yes. Paragraph 30, you say? Is it paragraph 30?
Yes.
Which portion?
To the candidates who have participated in the first SLST for classes 9, 10, 11.
I didn't get it.
The principal,
Principal issue.
the present, third line. The present appellants
Uh-huh.
are waitlisted candidates. They were not given any appointment letter. In such, it has been seen, it has to be seen whether they at all have any right to challenge the present recruitment process. In our respectful reading of the concluding paragraphs of judgment of Honorable Supreme Court encapsulated in paragraph such and such, certain benefits and concessions have been given to disabled candidates and candidates not specifically tainted. The disabled candidates were allowed to participate with appropriate age relaxation along with untainted candidates. These two categories of candidates could take part in the fresh selection with certain relaxation. Apart from the aforesaid two, no other category was specifically mentioned who would be entitled to any such relaxation or concessions in the fresh selection process to fill up vacancies. The appellants cannot be treated at par with disabled and untainted who were appointed but lost their job, as the entire selection process was vitiated by fraud. And in such background, in our respectful reading of the judgment of the Honorable Supreme Court, Paragraph 49, age relaxation was allowed only to such categories of candidates who were appointed in the said selection process, who were appointed. The reliance on paragraph 5 of the miscellany filed before the Honorable, in our view, does not come to the aid of the present appellants, as they were not given any benefits of age relaxation and other concession. Admittedly, they were not appointed. The appellants, by reason of mere participation, do not acquire any vested right. It is mere exception that in the event all the posts are not filled up, or any vacancy arises due to failure of a successful candidate to join the post within a stipulated time, if they are waiting list candidates, they would be considered for filling up such vacant posts in terms of the merit list.
তারপরে দরকার নেই
Has raised another issue, this is
ওই ইস্যুটা এখানে নেই
Not required.
তারপরে প্যারা প্যারা 35 সেকেন্ড লাইন প্যারা 35 সেকেন্ড second sentence, I'm sorry. Para 35.
35?
please see. I will request your lordship to first see paragraph 32.
Yes.
The policy decision of the government is subjected to judicial scrutiny only in exceptional circumstances, where it appears that the policy or some clauses of the policy is manifestly arbitrary, discriminatory, malafide, unreasonable, or unfair, or if it is found to be against any statute or constitution, if it is dehoes the provisions of the act or legislation, and if the delegate has acted in excess or beyond its power of delegation, such policy can be decided to be altered. The recruitment rules per se is not under here. It is a different case, intelligible differential. And then, Milord, please see 35.
Page 25.
Page 25, internal.
Second sentence.
If the government felt the experience gained by candidates is relevant, the court cannot
This
take
is
a
the
different
experience.
No, next sentence.
sentence. Similarly, prescribing any age limit for a given post and also deciding the extent to which any relaxation can be given to the said age limit are essential matters of policy. So, Milord, read in conjunction with 33, 32, and Milord with paragraph 30, Milord, I think
Compilation of 179.
no longer, Milord,
এটা paragraph.
no longer recipe.
Page 179 of the compilation is Supreme Court order
Milord,
upholding the.
Page 179 of the compilation, Milord, has not entertained the SLP from
Yes,
this
yes.
file.
I handed over that order, my lord. Arunima Swal SLP order, my lord. ওই তো দিয়েছি
179. 179 of that compilation.
This is the same date?
Yes, yes.
Same.
21st.
No, no.
Yes, yes, same date. 21st, it is there in the compilation. Is dismissed.
SLP having been dismissed, it presupposes that there is no merger, the bench's order remains.
Hmm.
And therefore, it's a one-line dismissal. So, what I respectfully submit, that these issues are being once again re-agitated in a different dimension, so as to, set at naught, or not to set at naught, the judgment delivered by the Honorable Division. The endeavor should be
এটা
to allow the
already-
process to
এটা বলছে অলরেডি টেন্টেড লিস্টে আছে এটা তাহলে বিষয়টা বলবো তো যখন Sure.
by raising issues which have already been put to rest by a pronouncement of the division bench and which has been carried before the Honorable Supreme Court and which has not been interfered with, it presupposes that the issue is no longer available for judicial scrutiny, subject to correction by my. Those are my submissions. Prima facie, on the question of interim order. CD matter, the other issue is coming up on 5th. That is what I am told. I was not there yesterday. One matter was moved as to.
You were not there yesterday in all the orders. Your name is reflected.
I do not know why it is different.
Yes.
I was not there.
Who put in the slips, please
I
inquire.
never inquired.
Because you should. You
No,
now henceforth you should. In all the matters, I saw your name and I just wondered that I didn't see Mr. Bhattacharya today.
I was,
Yesterday was-
yeah, in fact,
Check up, I do not know. The orders must have been put in the server.
your lordship should not sign those orders. Remove my.
It
name.
has
I was not
already
there.
been signed. And by this time, it should be in the server, possibly.
মেনশন
Right.
কারেকশনের জন্য এটা আনে না
Because, yes, because next time it will be mentioned that such and such person was not there. Because today you are saying that I was not there.
One matter, was sought to be moved. I know about the matter. It has.
Maybe.
Yes, but I was
It is-
officially not there.
See, to the court, it hardly matters.
Officially was not there. I am telling you, Lord.
Yes.
But there is no dispute. I was not
And
there. Professionally, I was
It
not
is,
there yesterday.
it is not possible for a
100%.
judge to recollect who's there, who's not there. We see only the body of the order. There are so many corrections in the date, in the number and names and everything. But then whoever puts in the slip, ensure that only
Yes.
the councils who are present, their names be put in. Otherwise,
It becomes embarrassing also for me.
একটা বলে দাও 37 এর নামগুলো আছে বলছে টেন্টেড লিস্টে নেম এন্ড রোল নাম্বার বোথ আর অলরেডি দেয়ার ইন দি টেন্টেড লিস্ট এই যে এই এক্সেস অ্যাপয়েন্টমেন্ট লেটার যেগুলো আছে না এগুলো নাম অলরেডি টেন্টেড লিস্টে পাবলিশ করা আছে নেম এন্ড রোল নাম্বার
But if your lordship also see 119 of their petition.
37 সুপ্রিম কোর্ট অর্ডার বৈশাখী অর্ডার
Court order,
yes,
where the
119.
paragraph 37,
Yes,
the list, whatever, it also has the list of excess appointment letters.
yes.
করেছেন জজ সাহেব অনেকবার
That is also one aspect of the matter.
What aspect?
Wanted to raise, that.
additionally these names should be declared also published
So
That these names should
already a
also be
part
the
of the
tainted
already-
list.
it is already part of the
It's
tent
already a
is.
part.
name and roll number both those who were given excess appointment letter
It is being sought to be raised, every day, kindly visualize whatever orders are made by your lordship. Ordinarily, we are acting on them. Commission, in terms of your lordship's order, has also published a list, last week, indicating the father's name, the category, everything. It is not that we are trying to, avoid anything. Whatever is possible from us, of us, we are doing it to the best of our ability, So these things, these allegations, are perhaps, not correct.
All right.
My lord, may I please? my
1
lord?
minute. The state
We are not
will-
seeking to accommodate anyone. Let us be very clear on this, Mr. Bandyopadhyay has made these submissions innumerable times. I think, every one of us who are appearing for the commission, we adopt that submission. We are not seeking to accommodate anyone. We are
Alright.
trying to do it at the best possible. There may be, some certain areas which your lordship is correcting, and we are also seeking to, do it.
State.
Malad, in a nutshell, Malad, I've been able to push through my points through the voice of Mr. Bhattacharya when he was arguing because he allowed me to assist him, Malad. So, Malad, as far as the other matter is concerned, Malad,
Matter means?
for the Polash Noshkor matter, after directing the list to be published
Yes.
with regard to Group C and Group D, your lordship has been pleased to keep the matter on 6th of January. Malad, your lordship in that Malad matter had been pleased to Malad observe that as a your lordship is not inclined to interfere with the process at this stage, Malad. Now, Malad, since the commission says that the list that they are concerned with today, Malad, is already published, your lordship will kindly restrict your lordship's directions because
But then this is a different issue altogether. He wants age
Age-
relaxation.
for age relaxation, Malad,
Along
that
with
submission has already been made by Mr. Bhattacharya
Yes.
that under in the interpretation of paragraph 49 of the Supreme Court judgment, who is supposed to get the age
So
relaxation?
that is the commission's part.
They have
You are
coined
the state and you are the rule making authority, right? So your rule is also under challenge.
Right. Malad, as far the rule is concerned, the rule is Malad resonating the same age relaxation which has been granted by the Honorable Supreme Court in paragraph 49. Malad, what I am trying to impress upon your lordship is that this category or this class which is sought to be created, that untainted, unselected candidate, that was not the contemplation of the Supreme Court ever. The Supreme Court made it very clear that one is a tainted category and one is a not specifically tainted category.
By the way, 1 minute. Commission, why don't you publish a list where the
can take-
names of the untainted candidates are there? So that they get to know that yes, I am not tainted.
Untainted selected candidates who lost their jobs in terms of the Supreme Court's order, untainted but selected. Who were working.
There is no other
There
category.
may
There is no other
be-
category.
There may be candidates who have not been selected, but they do not fall in the list of the tainted candidates. There may be candidates whose name fall in the tainted list, but they were not selected.
Then, perhaps, paragraph 30, perhaps your lordship
Has
just
to.
not agreed with your lordship, perhaps, it was my incapability, please fall back to paragraph 30.
Orunima Paul.
Orunima Paul, that issue has been covered.
My lord, not covered. I will.
I get it.
Yes, my lord. Now, my lord, may I place my lord, Mike?
Yes.
In reply, my lord, kindly take Oronima's, my lord, division bench judgment, para 34, internal page 24. I not place the whole paragraph. Internal page 24. 1, 2, 3, 4, 5, 6th line. Got it, my lad?
Yes.
6th line. The recruitment rules 2025 has not been challenged by any of the appellant. So in Orunima case, recruitment rules was not under challenge. Now, my lord, what is the recruitment rule? Kindly turn page
It
number
was under
74.
challenge.
74
Yes, my lord.
of your writ petition.
Yes, my lord. My repetition. The rules of CD 2025 rules.
Yes.
Page number 63. That is start of this rule. This rule may be called the West Bengal School Service Commission selection of person for appointment to the post of non-teaching staff rule 2025. This rule is under challenge in this writ petition in regard of age relaxation also. My lord, kindly turn page number 74. It is mentioned, first, my lord, the age is mentioned. Qualification. My lord, before that, page number 65. Rule 4. Qualification and age of the post.
Yes.
Qualification and age of the post. Subject to Rule 5, the qualification for the post shall be such as specified in column 3 of Schedule 1. 2. The age limit for the post shall, subject to provision of this sub-rule, be such as specified in column 4 of the Schedule 1. Upper age limit is, however, relaxable as per state government norms for scheduled caste, scheduled tribe, OBC, and physically handicapped candidate. Note 1. Age relaxation in connection with fresh selection process for recruitment of candidate to the post of non-teaching staff commences pursuant to the direction contained in the judgment and order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024 dated 3rd April 2025 shall be given in accordance with the direction contained therein and to be passed in connection herewith from time to time. I want the equality, my lord. Now, note 2. Age relaxation with regard to OBC candidate is subject to the orders passed by the Honorable Court from time to time. Now, kindly turn page number 74. What is Schedule 1?
Page number
74.
70.
It is mentioned in Rule 4.
Yes,
It is
yes.
according to the schedule, my lord, last column, age limit. In serial number 2 and 3, that these two category, clerk and group D, minimum 18 years and maximum 40 years as on 1st January of the year of advertisement, relaxable by 5 years for scheduled caste and scheduled tribe candidate, 3 years for OBC and not subject matter of any litigation, 8 years for the physically handicapped candidate. Nota bene, NB. Age relaxation in connection with fresh selection process for recruitment of candidate for the post of non-teaching staff commences pursuant to the direction contained in the judgment and order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024 dated 3rd April 2025 read with order dated 17th April 2025 in MA number such and such shall be given in accordance with the direction contained therein and to be passed in connection therewith from time to time. For consideration application such and such, I did not place it. Now, my lord, recently Vivek Paria, the last page. Because that Orunima matter went up to the Supreme Court. What Supreme Court observation in Vivek Paria to remanded back all the subject matter to this court, my lord. It is, I just read it again, the cost of repetition. The High Court shall examine the matter uninfluenced by any of the observation on merit made by this court in order passed after the decision in Boishaki Bhattacharya Chatterjee Supra. The High Court shall also be mindful of the fact that the untainted candidate in the first selection were allowed to sit for the selection test to be held afresh. Their candidature cannot be adversely affected by application of new rules. That is the West Bengal School Service Commission Selection for Appointment Rule 2025. So my case is that, my lord, in Orunimapal is a distinguishable case. In Orunimapal, the division bench observation was that there was no rule challenge. Their rule is under challenge. I want, my lord, equality. That being an untainted candidate, being a not specifically tainted candidate, because I am untainted, I could say so because I not get the service, because being an untainted candidate, I am also eligible for age relaxation. The points of equality, my lord. My lord, this case, my lord, adjudicated as a fresh matter because of that, my lord. That is the Supreme Court, my lord, order, my lord. And not only that, my lord, I have another prayer is that my lord, publication of tainted list and not specifically tainted list, and as well as, my lord, include all the categories, my lord, and mentioning the category. That is most important, my lord. Until and unless that is happened, my lord, we will not get the proper justice.
Did you find the name of any candidate whose name is there in the wait listing, in the wait list, included in the tainted category?
No, not yet. Not yet. Because of that, they published in these two category list, as per my humble understanding, that well, in 9, 10, 11, 12 category, they only published the tainted teacher list of 1,806 candidates.
Those
And
who were appointed.
those who are appointed. And in Group C and Group D category, 3,512 candidates. But actually, the in Group C, Group D candidate, Malad, last time I mentioned it, more than 7,300 candidates, Malad, they ought to put in the tainted category list because as per their list. And as well as in 9, 10 categories, that might be hiring up, that ought to be 2,082 candidates, and that would be more number because of that, Malad, this recommendation and appointment mismatch category. So only the Article 12, because it is evident from their affidavit, not from any others affidavit. Because of that, they themselves ascertain those candidates as a tainted one. This Article 12 authority, this I could say 3 Article 12 authority, that is SSC, West Bengal Board of Secondary Education, and CBI. These three, list, my lord, if they compared with each other, then only, my lord, the proper tainted list will be ascertainable. Otherwise, not, my lord. They ought to sit together, my lord. Until and unless they sit together, my lord, it is never be happened. The SSC by their own they put the a list, but this.
Please come.
May I only clarify two things, my lord.
The petition was presented beyond on the 2nd of December 2020.
Yes,
This petition, which is both beyond the Honorable Supreme Court. Supreme Court never had, kindly pardon me for saying, the Honorable Supreme Court was not considering any wait-listed candidates.
they are uninfluenced. They say so. I challenge the rule.
By not interfering with Purunima, has put the question to rest. The matters which are Vivek Paria and whatever is being shown to your lordship is not at the instance of wait-listed candidates.
It might be.
Not at the instance, but that question perhaps is no longer open, subject to correction. Your lordship may record.
Muller, I wanted to one factual aspect I wanted to clarify, Muller, at the cost of several repetitions, Muller. Orunima Pal had challenged the rules. Muller, we have given the writ petition without annexures in your lordship's compilation for your lordship's satisfaction at page 122. The rules were under challenge. We have shown to your lordship. So, Muller, factually, it is incorrect to say that the rules were not under challenge. Number one, other submission, Muller, we will make at the appropriate time in the appropriate matter. And the second question is that perhaps the endeavor of Mr. Bhattacharya to show Orunima Pal, no one is denying that last paragraph. But the endeavor to show Orunima Pal is that when the Honorable Supreme Court says that also to be mindful of the fact that the untainted candidate in the past selection process, it has to be read with that paragraph 30 of Orunima, that this untainted candidates means who were already appointed, not waitlisted, whose rights were not crystallized, as the division bench has held. That those who were not appointed, their rights had not crystallized into a vested right. No one verified waitlisted candidates ever. Neither CBI, nor commission, nor board. They were never under the scanner. So this terminology that they are coming up with, untainted, unsuccessful candidate, it was nowhere under consideration ever.
Which my learned friend, my lord, says so. My lord, I just given instances, my lord. Kindly turn page number 130.
No, the matter is likely to the division.
কালকে ছিলেন আজকে থাকো
ভাই তোর সাথে কিছু হবে কালকে বলছে
kindly turn page number 113.
113.
For the cost of repetition, what my learned friend says, my lord, what would the meaning of that? My lord, kindly turn page number 113 in the cost of revenue, table 2, just table 2. My lord, in assistant teacher 910 category, total OMR mismatch is 952. Out of that, 808 candidate got appointment. So other remaining candidate, according to their submission, they are untainted because they not considered whitelisted candidate as per with the others who got appointment. So if their submission is sustainable, then as per the CBI list, whosoever the tainted not got appointment, they will not be treated as tainted.
So they are in the wait list. These 150 are in the wait list.
We are also 8 listed candidates.
There was,
We
no,
want
there was no
equality.
scanning.
We
There
were-
was no
we want
scanning with regard to
equality.
this.
That's my point. And we
Repeatedly
challenge the
reopening
rule.
same things
We
which has
challenge
been
the rule.
Finally,
In earlier occasion, Aurunuma Parliamentary rule was not placed.
সিনিয়র বলছে তো যে আপনি এসব গোপা বুদ্ধি দেয় গোপার বদ বুদ্ধি যাচ্ছে
How many petitioners are there? 14. Court fees?
Well, already given, Malad.
Check up,
But
Vilesh.
Malad, I give it. If not given, Malad, I give it here.
The petitioners claim to be the candidates who participated in the 2016 recruitment process for being appointed appointed as non-teaching staff as clerk and group D.
পরেরটা তো আনটি পরেরটা তোদের নয়
The petitioners were not successful in the said recruitment process. Stop. By virtue of the judgment passed by
মাঝখানে মামলাগুলো কি হবে
this court, duly affirmed by the Honorable Supreme Court
হ্যাঁ মাঝখানে গুলো কি আমাদের আছে
in
14 দিয়ে দিতে তাহলে ওই স্ট্যাটাস থেকে গেট কর ওইটাকে দেখিয়ে দিই কতটা নেক্সট
civil appeal arising out of SLP C number 9586 of 2024. State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and others. On 3rd April 2025, the entire selection process was nullified. Stop. The Honorable Supreme Court, however, made it clear that the candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation in the fresh selection process to be conducted by the Commission to fill up the vacancies. Stop. In compliance of the direction passed by the Honorable Supreme Court, the West Bengal Central School Service Commission has initiated the recruitment process for filling up the posts, filling up the vacancies of clerk and group D. Stop. The rules as per the the rules in accordance with which the recruitment process is to be conducted was notified on 4th August 2025 in the Kolkata Gazette Extraordinary under the name and style of West Bengal School Service Commission bracket open selection of persons for appointment to the posts of non-teaching staff bracket close rules comma 2025. The age limit as prescribed in the said rules is minimum 18 years and maximum 40 years as on the 1st of January of the year of the advertisement, relaxable by 5 years for scheduled caste / scheduled tribe candidates, comma 3 years for other backward class candidates, and 8 years for the physically handicapped candidates. A note has been inserted in the rule mentioning that age relaxation in connection with fresh selection process for recruitment of candidates for the posts of non-teaching staff commenced pursuant to the directions contained in the judgment and order of the Honorable Supreme Court in Civil Appeal number 4800 of 2024, dated 3rd April 2025, read with the order dated 17th April 2025 in MA number 709 of 2025. Shall be given in accordance with the directions contained therein and to be passed in connection therewith from time to time. Stop. In line with the above rules, comma, a notification has been published by the Commission on 9th October 2025 for conducting the first state level selection test, 2025 for recruitment of non-teaching staff within bracket clerk and group D only bracket close in recognized government aided / sponsored schools in West Bengal. Stop. The opening paragraph of the said notification mentions about the order dated 3rd April 2025 passed by the Honorable Supreme Court in Civil Appeal number 4800 of 2024. The petitioners have crossed the maximum age as prescribed in the rules followed by the advertisement. Stop. According to the petitioners, comma, the age relaxation, না দি হবে না, age relaxation, petitioners এর পর comma হবে, age relaxation ought to be given to all the candidates who participated in the 2016 recruitment process, irrespective of the fact whether they were appointed or not. Stop. Submission of the petitioners is that the authority ought to have conducted the recruitment process strictly in terms of the judgment passed by the Honorable Supreme Court by providing the age relaxation. Stop. Not providing the age relaxation to the candidates who were not appointed in the recruitment process conducted in the year 2016 would adversely affect their rights. Stop. Next. The orders passed by the Honorable Supreme Court in the matter of Boishaki Bhattacharya within brackets Supra and the order dated 26th November 2025 passed by the Honorable Supreme Court in special leave petition within brackets civil diary number 46049/2025 Bibek Paria and others versus the state of West Bengal and others has been placed before this court to impress that the Honorable Supreme Court has directed the High Court to be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection tests to be held afresh, and their candidature cannot be adversely affected by application of the new rules. It has also been brought to the notice of the court that in the same order, the Supreme Court recorded that the High Court shall ensure that the list of tainted candidates is placed in the public domain with full details so as to ensure that the same does not happen. Stop. The parties were given liberty to raise all issues before the High Court. Stop. The Honorable Supreme Court was also pleased to record that the High Court shall examine the matters uninfluenced by any of the observations on merits made by the court in the orders passed after the decisions in Boishaki Bhattacharya within bracket Chatterjee within bracket Supra. Stop. As an interim measure, it has been brought to the notice of the court that the last date for filing the forms in terms of the advertisement was 3rd December 2025, that is today, but the same has been extended till 8th December 2025. Stop. As an interim measure, prayer has been made to permit the petitioners to fill in their application forms subject to the result of the writ petition and to direct the commission to publish the list of the tainted candidates with complete details along with a separate list of candidates not specifically tainted, so that these candidates can participate in the recruitment process in accordance with the direction passed by the Honorable Supreme Court. Paragraph. The prayers made by the petitioners have been opposed by the learned counsels representing the state and the commission. Stop. It has been submitted that whether the candidates who were not appointed in the 2016 recruitment process have a right to challenge the fresh recruitment rules has already been decided by the Honorable Division Bench of this court with a judgment dated 16th July 2025 in MAT 1017 of 2025, Can 1 of 2025, Orunima Paul and others versus State of West Bengal and others. In Orunima Paul within bracket Supra, the court was pleased to observe that the policy decision of the government is subjected to judicial scrutiny only in exceptional circumstances where it appears that the policy or some clauses in the policy is /r manifestly arbitrary, discriminatory, malafide, unreasonable or unfair, or if it is found to be against any statute or constitution. The court specifically observed that prescribing age limit for a given post and also deciding the extent to which the relaxation can be given to the said age limit are essentially matters of policy. Stop. The constitutional courts in judicial review does not function as appellate authorities to examine the correctness, suitability, and appropriateness of a policy, nor full stop hobe na, nor they function as advisories to the executive on matters of policy which the executive is entitled to formulate. Stop. It has been pointed out that the special leave petition preferred against the judgment passed in the matter of Orunima Paul stood dismissed by the Honorable Supreme Court on 21st July 2025 in petition for special leave to appeal within brackets C number 19222/2025. Stop. It has been contended that the court in Orunima Paul clearly laid down that by mere participation quote that by mere participation a candidate does not acquire any vested right. According to the Honorable Division Bench, only the candidates disabled candidates and the candidates not specifically tainted were allowed age relaxation and could take part in the fresh selection process. Stop. Apart from the aforesaid two categories, no other category was specifically mentioned who would be entitled to such relaxation or concession in the fresh selection process to fill up the vacancies. Stop. It has been argued that once the issue has been set at rest by the court in the matter of Orunima Paul within brackets Supra, the said issue ought not to be re-agitated all over again. Stop. Next. It has been submitted that the list of tainted candidates has already been published and steps are being taken to disclose the details of the said tainted candidates in terms of the order passed by the court. Stop. Paragraph. The matter is at a very preliminary stage. Stop. The for effective adjudication of the instant lists, the parties ought to be given an opportunity to disclose their stand by way of an affidavit. Stop. The respondents may file their stand by way of a report supported by an affidavit. Stop. as an interim measure. Now, the court is only at this stage, Shuru Korun, at this stage, the court is considered. The court is considering as to whether any interim relief can be granted to the petitioners. Stop. The Honorable Supreme Court in Boishaki Bhattacharya within brackets Supra permitted the candidates not specifically tainted. Permitted the candidates who participated in the 2016 recruitment process and who are not specifically tainted to be eligible to participate with appropriate age relaxation. Stop. It is an admitted fact that the Commission has not yet published any list of candidates not specifically tainted. The Honorable Division Bench in the matter of Arunima Pal also took note of the fact that it is the candidates not found to be specifically tainted who may be permitted to take part in the selection, in the fresh selection process with relaxation. Stop. In the absence of a list disclosing the names of candidates not specifically tainted, the Commission possibly cannot restrict the age limit only to the candidates who have been found whose names do not appear in the list of tainted candidates published by the Commission. Stop. The candidates in the recruitment process of the year 2016 has now to be taken as two sets. One of the tainted ones whose candidature the Supreme Court has not approved of and has kept the tainted candidates specifically out of the selection process, and the rest, the untainted candidates, have been directed to participate in the recruitment process. Stop. The division bench in Arunima Paul was also of the same opinion that the untainted candidates be permitted to participate with age relaxation. Stop. It does not. Now, none of the orders passed by the courts, either by the Honorable Supreme Court or the High Court, mention that the untainted candidates or the candidates not specifically tainted should be restricted only amongst the candidates who were given appointment. Stop. It may be the candidates who did not get appointment because the tainted candidates were put up in the list for the tainted candidates were provided appointment. Stop. Had the tainted candidates not been given appointment, many of the other candidates who are not specifically tainted could have got the job. Stop. The court, time and again, has reminded the Honorable Supreme Court, time and again, reminded that the High Court should be mindful of not allowing any of the tainted candidates to participate in the selection process. Stop. The same implies that any candidate who is not specifically tainted would be entitled to participate in the selection process. Stop. In view of the above, the court is of the prima facie opinion that at this stage, the commission ought to publish, not at this stage, the commission should immediately publish a list of candidates not specifically tainted so that they may take part in the fresh recruitment process if they choose to do so. Stop. The candidates who do not fall within the list, who do not fall in the list of tainted candidates, but are included in the list of the candidates not specifically tainted, be permitted to take part in the recruitment process with appropriate age relaxation. As the last date for filing the application form has been extended till 8th December 2025, the commission shall take steps to publish the list prior thereto so as the candidates not specifically tainted can participate in the recruitment process with appropriate age relaxation. Stop. The let the matter appear in the list on 6th January 2026. When in January the other matter was fixed. 6th January 2026. Prior thereto, the pleadings of the parties be concluded.
Just to
But I am praying for stay of operation of the order.
My lord, affidavit of service and my lord, court fees, and another thing is that my lord, Orunima Pal matter is regarding group C 9-10 matter. This is group C, group D. My lord, kindly note that. And another thing is that my lord, I want to cite just one judgment, my lord, although it is in compilation, my lord, because of the third party can.
1 minute. Affidavit of service ke record e রাখবেন. Deficit court fees receipt দেওয়া আছে. This will be taken on record. Mr. Bandopadhyay has prayed for stay. ওটাকে রাখুন. Yes.
My lord, Orunima Pal matter is regarding 9-10 elementary. This matter is a non-teaching group C, group D. Rule is separate. The challenge is by the separate
Principles are same.
আরেকটা লাইন,
Principles of law are same.
আরেকটা প্যারাগ্রাফ অ্যাড আপ করুন. Specific contention of the respondents is that the rule pursuant to which recruitment was being conducted for assistant teachers in classes 9 and 10 and 11 and 12 was under challenge in Orunima Paul within bracket Supra. ঠিক আছে? Be it recorded that in the instant case, the rule which is under challenge is the West Bengal School Service Commission bracket open selection of persons for appointment to the posts of non-teaching staff bracket close rules, 2025. And though it has been asserted by the respondents that that a similar rule was under challenge in the matter of Urmila Paul, but the court has noted that the Honorable Division Bench had specifically observed in more than one places that the rule is not under challenge per se, that the recruitment rules, 2025 per se is not under challenge. That's it.
Orunima Pulse rule is separate and this Group CD rule is separate. And the states of candidates is also separate.
Or anything else?
Well, since this, apropos to the last submission being made after the order, anyway, Malad, what my submission was that the principle of law will apply equally to both the cases, number one. And number two, Malad, I have also indicated from the compilation filed by the commission that the rules were in fact in challenge, Malad, that is at page 122 of the.
Mention that you assert that the rule is under challenge.
Yes.
The court has recorded that it is not under challenge.
Yes.
Now we go by the court's order.
Good.
Yes. And Mr. Bandyopadhyay, after the order is dictated in open court, the commission prays for stay of the same stuff paragraph as the court has considered such prayer and refusing to stay the order passed here and above. ঠিক আছে? একটু পাঠাতে হবে।
But ABD service and court fees both.
Yes, that will be taken on record. এগুলোকে রাখবেন file.
Next matter.
Yes, next matter please.
Next matter, ABD service and court fees kept on record.
In the next matter,
Yes,
item 8.
8.
Yes.
But this matter is also Group C, Group D, but in the same line of Polash Noskor with an extra prayer. What is that extra prayer and why? Prayer Polash Noskor I already handed over, my lord.
আচ্ছা এর আগেরটাতে বোধহয় পলাশ নস্করটা আছে, ওটা দিন তো, ওটা কাজে লাগেনি।
May I hand it over again?
ওটা কাজে লাগেনি। না মোটাটা না, একটা পাতলা অর্ডার, দুপাতার অর্ডার, ওটা না। হ্যাঁ।
Polash Noskor আছে? But may
Yes,
This compilation also your lordship keeps with your lordship.
একটু এইখানটা
ওই কম্পাইলেশনটা দিয়ে দিন, 15 থেকে মামলা করতে লাগবে।
এটা এখানে থাকুক, পরে ওটাকে চেম্বারে পাঠাবেন।
you know.
Yes.
My lord, in this line, my lord, I have a prayer. Although I challenge the rules in Polash Noskor matter also. In this matter also, my lord.
Is পলাশ নস্কর pending?
Yes.
Yes, 6 January. 6 January.
6 January, yes, my lord. But because of that, my lord, this 10 marks argument is going on, my lord. In the same line, rule is challenged. 5 marks is also challenged. That is given for the experience marks. But in this matter, my lord, all the tented list and untented list is already Polash Noskor matter, my lord. Pass that order, my lord. But my lord, one thing is that is not yet, my lord, published by the West Bengal Central School Service Commission. That is counseling wise list in the 2016 selection process. Why it is required?
Not in the prayers.
I remember there is specific prayer.
No, there is no interim prayer with regard to that.
Yes, but prayer H is that, my lord. My lord, why?
There is final relief.
Why
sorry.
my submission?
Yes, I'm sorry.
Sir? Why that is required? Because of that, my lord, in Vivek Paria matter, Supreme Court says not even a single tented candidate slipped through the net, my lord. But kindly turn page number 130.
Was পলাশ নস্কর challenge?
Not yet. As per my information is subject to correction. But kindly turn page number 130.
130?
Yes, my lord.
Yes.
There are 4, one after another, that is central West Bengal Central School Service Commission, my lord, their chart, my lord.
Hmm.
From that chart, it is evident when the panel expired, my lord.
Hmm.
In four category: Group C, Group D, 9, 10, 11, 12. Some of the counseling, in case of just my lord, in the instance of 11, 12, that is 5,712 posts. Publication of final vacancy. Thereafter, date of publication of final panel 27th November 2017. Panel validity for 1 year, that is ended on 27th November 2018. Thereafter, my lord, kindly see the date of first counseling 16/7/2018. Thereafter, second counseling.
All after the expiry of the panel.
Expect first and second. The third onwards,
Yes.
far onwards, all are after expiry of the panel.
Yes, 19.
Yes.
All after.
And the very next page, same line. Very next page, Group C, Group D, in the same line. All after 2-3 counseling, my lord, all the counseling are after expiry of the panel. Now, my lord, I am placing the Supreme Court, my lord, judgment, my lord, para 30 and 31, which is annexed with my writ petition. Why I ask for this counseling wise list?
Page 130 is in respect of the Group C, Group D.
No, my lord. Page 130 is respect of 11, 12. Page
This
131.
writ petition is about
Group C, Group D, at 132 and 133. I says it because of that combination. That judgment is combination of four
Yes,
selection.
yes.
That's why I annex the four.
all right. But then 132 is Group C.
Yes, Group C, and 133 is a Group D.
All right.
So that's why I annex all these to showing that there is an expiry panel appointment, and Supreme Court take note of that, my lord.
All right.
I will place the Supreme Court judgment later on, my lord. So, my lord, in Group C, Group D also that is happened, my lord. So after panel, after expiry of the panel, there is an appointment, my lord. So they ought to publish the counseling wise list, my lord. Until and unless they publish the counseling wise list, how could because Supreme Court Vivek Parya matter is that might be in public domain. Until and unless it is in public domain, how could a candidate or any citizen ascertain who are that tainted candidate after expiry of the panel?
Want in this matter, you want the publication of
Counseling wise panel.
counseling wise.
Because before that, my lord, I just want to, my lord, canvass that Supreme Court judgment, page number 98. What was the Supreme Court observation regarding this expiry of panel? My lord, it start from judgment, start from
All right, page 98.
page 67, page 98.
Only one sentence I should. Since
Who are you now?
our lordship is hearing the point of the expiry of panel.
Yes.
Now, this law point might get affected in the hearing which is continuing. All I say, lordship may pass any order because lordship is in the midst of it.
I make
Because paragraph 31 has been shown.
no, I am not 31. I am on 30.
Absolutely no difficulty. But all I request your lordship that kindly hear us on the point of expiry of panel and thereafter. Because prior to that, my lord, any kind of, my lord, slightest comment, my lord, that.
See, this is what I was thinking, and I'm making myself clear so that they also get to know. There is an issue of stigmatization which was highlighted yesterday, that if the list of the tainted candidates is published,
That is
then
what
these
tainted-
candidates get
Yes.
stigmatized. So why not publish the list of the candidates not specifically tainted? So at least for the time being,
No,
they can avoid the stigma.
But that's absolutely fine. I say different. List of the not specifically tainted, absolutely fine. List of even tainted, absolutely fine. But list of the persons who are not tainted, but might become tainted if lordship holds that after expiry of panel, because they have been appointed, If that comes today, all I'm saying, kindly hold that part.
As of now, you are not in the tainted list.
I'm not in the tentative.
So if they publish a panel not specifically tainted, your name may go there.
There is no difficulty.
Thereafter, the court hears the matter
Yes, yes, yes.
and comes to a conclusion that the candidates who were given appointment after expiry of the panel will be treated as tainted, then your name will automatically go out from the list of the not specifically tainted.
Comes, there is a likelihood that if Mr. Mikro does not begin, it will come today. I would be able to, my lord, 100% show and satisfy your lordship. Out of 8 counselings, all the 7 counselings, those were found by the CBI itself, yes, after expiry. That's why it is illegal, but not tainted because of XYZ reasons recognized by the Honorable Supreme Court. As and when it comes.
Yes,
Right, right.
but then your apprehension
Yes,
that if you fall
yes.
will be taken care of.
But so far as the list of untainted, no apprehension, no problem. So far as the list of tainted, no apprehension. Only apprehension is
Presently untainted, later tainted. That is the apprehension.
no. I would not even use that. List of candidates appointed, not tainted, but after expiry.
Yes, this the court has to decide whether it will be within the tainted list or not.
My response in one sentence: it has been
Decided.
decided.
Very well. The court will
Decided.
see.
That's what I'm saying.
You'll get a turn and
My lord, and now, my lord, I place the
Say that since lordship is hearing, ultimately it's everything is, my lord, interconnected. So maybe I was little excited only for this reason, because once lordship
I have followed
understand, it would be extremely difficult.
and I understand. I
That's-
understand your problem.
my lord,
Yes.
may I place? Because before that, my lord, because I'm learned senior friend, my lord, intervene in this matter.
No, it
I just yes, I am not. I just say that I am not asking for that after expiry of panel. I am asking for the counseling wise that might be that they are absolutely fine, but I am not asking for
That's
the
absolutely fine.
yes. I for that is the reconcilement. I am not asking for any expiry of the panel. My prayer is very restricted that counseling wise list. That's my point. The court might hold that
No,
yes,
so what is your prayer right now? You want the list of the
counseling wise,
panel as per the council.
counseling wise list. Because
Yes.
why so kindly turn page number 98.
What is the primary challenge?
Primary challenge is rule, my lord.
Rule.
Rule 5 marks, 5 marks.
All right, that means the rules
that
itself.
means rules itself, my lord.
Right.
We call it
Now-
and that tainted list as well as not specifically tainted
All
list,
right.
which is already covered by earlier order.
All right.
And
And you participated in the earlier recruitment process.
yes,
And,
I participate in this selection process also.
Yes.
But
Here you participate.
my wife wants to participate. my lord.
Want to participate.
Yes, I want to participate, and there is no relaxation is required, my lord. I want to
You are
participate.
within age.
Yes, yes, my lord. And but I want, that's my prayer, my lord.
All
And
right.
but the counseling I want, my lord, the counseling wise list. And before that, kindly turn page number 98, my lord. Why I placed it, my lord. Page number 98, para 30.
But then, if the rule is under challenge and we can decide that, why is this list of counseling required immediately at this stage?
Counseling wise list, it be because of that, my lord. If my lord hold it, suppose my lord hold it, that there might be opportunity. Two things might happen. One is that my lord might hold that yes, up to 8 round of counseling, everything is okay and fine. That is separate thing. If my lord hold it, that no, after 3rd round or after 4th round counseling, illegal or expiry of the panel, then my lord, that list is required.
All right.
So that purpose, my lord, that before expiry of the panel decided, this counseling wise list is required. That's my prayer, my lord. Because it will not harm anyone, my lord. It is a very innocuous one. Because of that, they already, my lord, hold it They gave appointment, counseling wise they gave appointment, and they might published it, my lord, counseling wise. And not only that, my lord, on instruction, although yesterday night, my lord, I searched it, I did not get it. By on instruction, I say so the board can appraise this court. After at that point of time, up to second round of counseling, board in their website, West Bengal Board of Secondary Education. Although yesterday night I gone through it, but I not get it. Up to second round of counseling, board in their official website uploaded whoever got appointment up to second round of counseling. Board in their official website they published, but after second round of counseling they never published it. That's my instruction, but it may be wrong. But yesterday night I gone through the board's website, I not get it. Might be they withdraw it.
Yes.
Can I make my submission there?
Yes, certainly.
Madam, kindly come to page 131, which he has cited. 130.
Yes, 130.
Very misleading statement is being made by the writ petitions. Page 130 is related to teaching and teaching staff. I mean class 9, 10, 11, 12. 131, 9, 10. Then 132. Group C. And Group C, kindly see, everything was done before expiration of the panel.
The last round is after expiry of the panel.
Wait, please wait.
You have said earlier after second round.
That is regarding 9.
After second round.
Yes.
Now, kindly see here, date of fourth counseling was 31st December 2018. Then number of vacancies so and so. Status of panel expired on 18 May 2019. Then before that. Then next one, 133 also, Group D. Date of fourth counseling was 31st December 2018. Status expired on 4th May 2019. There were his statement in the submissions of them. Then that's all right. 130 is concerned, but that will deal with in the teaching staff matter.
Yes.
That there was a stay of operation of the order, will deal with that. Therefore, whatever the submission is being made, that's totally to misguide this court, to mislead this honorable. There are number of matters it has been done. Anyway, now for the timing it is there. Now, secondly, Millard, what is his legal right to ask for all the types of counsel? One of the most unsuccessful person is disturbing the court, is disturbing us. That is also not appreciated. This time he has filled up. Anything is wrong, that's a different thing. But it cannot be opened like an ocean. Simply because 2025 rule has been challenged. 2016 you are asking, not asking. He didn't ask from the 2016 when the writ petitions have been moved. Group C, Group D. Everything, every prayer was there in the earlier petitions. I will show it to your lords, which has not been allowed. Now he is asking, he want to open like an ocean. Therefore, I will make a request that your lordships do not kindly do not pass any interim order. My lord, your lordships have said regarding the tainted list of the tainted. We have published it. We have published it, and somewhere we are publishing. I've said. So far, the untainted is concerned. Also, my lord, we have specifically untainted. It's a term is being used by the learned councils. Supreme Court has never said about specifically tainted or tainted. Supreme Court has untainted and tainted. And untainted is restricted to only the persons who are in the employment. All benefits should go to them, not to anybody else. Those who are in the waiting list, CBI has not made any inquiry. Then they are kindly direct the CBI who are in the waiting list whether their candidate will come for tainted or untainted. CBI only restricted. CBI has restricted his investigation only to the persons who were in employment. CBI has not crossed the limit, and who are the unlisted, waiting listed candidates, no investigation was made on their case. That doesn't mean it should be treated that they are untainted.
As I was indicating, my lord, if your lordship kindly comes to page 36. Page 36 for the writ petition, my lord.
Yes.
The prayer my learned friend is relying on, prayer H, is a final relief that he has claimed on the basis of pleadings, my lord, which your lordship may accept finally or not. If your lordship kindly takes prayers K, L, and M, my lord, none of these prayers are related to any category-wise publication of any list. My lord, the foundation of his prayer today is some people may have been engaged, appointed after the expiry of panel, as I have understood, my lord, because he may have made submissions, but I have not found any foundation in the first list, second list, first counseling, second counseling, etc. Ultimately, the buck stops that the panel expired on so and so date. Some people may have been appointed after that date. Your lordship has already pronounced an order, my lord, in Polash Noskor, that is WPA 22580. Polash Noskor, sorry. The Polash Noskor WPA number is not, I'm sorry, 24996 of 2025. That is 1st December. Your lordship will kindly take paragraph 10 thereof. Your lordship has already directed the commission that as regards the candidates who were given appointment after expiry of the panel, their details shall be produced before this court on the returnable date.
This is in respect of only 9 and 10, isn't it? 9, 10, 11, 12.
It is Group C, Group D. Kindly see
This
paragraph
is
1.
Oh, actually.
Group C, Group D, your lordship has
Right,
already directed the names to be produced before your lordship,
All right.
those who were appointed after. Therefore, my lord, if his claim, as my learned senior, my lord, appearing for the commission already submits, my lord, if his claim is pertaining to people engaged after the expiry of panel, my lord, his cause of action was of 2018 and 2019. Therefore, his cause of action is not related to promulgation of the rules which is under challenge. The mere promulgation of the rules does not give someone a right to challenge it.
Just to indicate two things, my lord.
Yes.
My lord, kindly turn page number 132, my lord. What learned senior friend, my lord, says that none of the in Group C, Group D category, none of the counseling is held after expiry of the panel. Entry 9, date of publication of final panel, 2012-2017. Panel expired on 2012-2018. Now, my lord,
18th May 2019.
Was it extended? Was the life of the panel extended?
never be.
Because page 132, the second
Entry never be. It never. That's the was argument
Alright.
for the and
All right, I'll
and
see.
in each and every column they say so, and that was not accepted by the apex court. That is para 30 and 31.
The petitioners participated in the
My lord, a new argument has been made. Kindly see the rule. Earlier rule of 17. 2009.
The recruitment process for
My
appointment
lord,
as
my lord.
non-teaching staff. Stop. They challenge.
Seven.
They challenge the
Kindly see the rules.
bracket open
Once time I was there in the to extend.
for appointment to the posts of non-teaching staff bracket close rules, comma 2025. Stop. The petitioners also pray for an interim order directing the commission to publish the list of the candidates called for counseling in the earlier selection process conducted by the commission in the year 2016. Stop. Paragraph. The matter will be decided upon exchange of affidavits. Stop. Released for further consideration on 14th January 2026. Stop. All pleadings must be concluded prior to the adjourned date. Stop. The interim order that the petitioner is praying is being refused at this stage.
Grateful, Malak.
Service is taken on record and the deficit court fees also taken on record. ठीक है?